Time now for the Daily Answer, sponsored by Salem Surround on The Answer Now TV.
Michael O'Neill is the Vice President of Legal Affairs at Landmark Legal Foundation. It's depending on who you listen to, Michael, and I welcome you in this morning. Some say that the Supreme Court was largely skeptical of this, while others say, Treasury Secretary Scott Bessent said after oral arguments he felt very confident. How do you read it? Good morning.
Good morning, Chris. About 2.5 hours of oral arguments, so extensive arguments, robust questions for both sides. Let's try to play it straight down the middle and try to give you an objective analysis of what happened. So you saw the best arguments proffered by the president is that he has broad statutory authority under it's the International Emergency Economic Powers Act. I know that's a lot to say, but he has broad powers to regulate commerce in situations of emergencies, when we have emergencies. Now, if you engage in a statutory textualist interpretation of that, you really want to look at what does regulate mean? What does emergency mean? Now, does regulate encompass the imposition of tariffs? There's some textualist arguments about that. You could argue that regulate is a broad term, and certainly tariffs fall into that. The counter argument to that is that, well, tariffs is a specific term, and it's used in other parts of statutes, in other parts of the U.S. Code. And if Congress wants to convey the power to regulate tariffs and to impose tariffs, it will say tariffs. It won't just say regulate. It will include the word tariffs. So that's a textualist argument. That's something that a justice like Amy Coney Barrett really focuses on. Textualist arguments. Let's talk about a broader issue, the major questions doctrine, which you've probably heard a lot about when we're talking about this particular case here. We know that was a doctrine that was utilized by the court several years ago in a case called West Virginia versus EPA. This was part of the Green New Deal, the Clean Power Plan that the Biden administration was trying to impose, Biden's EPA was trying to impose upon the American people to vastly change how our country generates electricity. And so the court said in cases of vast and significant economic consequences, with cases that have vast, significant political or economic consequences, you're going to have specific delegations of authority, clear authorizations of authority within the statutory language from Congress. So the MQD, the major questions doctrine, certainly is going to play a part in that. The argument the Trump administration proffers regarding the major questions doctrine is this. Well, it's not applicable in foreign affairs. If the president is looking outward in trying to regulate, in trying to engage in diplomacy, like you're saying, using this as a tool to negotiate relationships with other countries, he's operating at his highest power, at his highest Article II power, and it's outwardly facing. So the MQD, the major questions doctrine, is applicable for domestic issues, not necessarily applicable for international issues. When the president is trying to negotiate these trade deals, when he's trying to effectuate diplomacy with other countries, and I think that really is probably the best standard for him the best kind of island for him to stand on is that, hey, look. This is an emergency. I need this to negotiate these trade deals. I've been doing it, and it's been largely successful. So, as you said earlier, Chris, Amy Coney Barrett had focused on the practical problems of this, and the horse is out of the barn, and the court is going to be aware of that. You know, Chief Justice Roberts is keenly aware of specific practical implications of their decisions. So that certainly is something that the court is going to have to consider, the actual practical effects of how you would remunerate or redress this money that we've already collected. Again, we're talking tens of billions, I think maybe even hundreds of billions of dollars at this point.
Michael O'Neill, Vice President of Legal Affairs at Landmark Legal. Gorsuch is one of those guys that kind of had a line of questions yesterday that would seem to indicate he's not supportive of the president's position here. Yeah. And he was making the case, and it's a free market case, I'll hear, a guy like our friend Steve Moore. He didn't like this tariff stuff. He's predicting the court overturns it, as a matter of fact. And Gorsuch said, well, what constitutes an emergency? Could another climate president, a green president, come in and say, these gas-powered cars are a problem, and I'm going to slap a huge tariff on gas-powered cars because we have a climate emergency? It's a valid point he makes. So does that apply here, in your view?
I think it could apply, and I think even the Solicitor General had to answer in the affirmative with that, right? I think when you were listening to the oral arguments, he even conceded that. So you had Trump's own attorney, the Solicitor General, who obviously is pro-tariffs, had to concede that, and that caused a lot of consternation amongst conservative lawyers, libertarian and conservative lawyers, as you would expect. Okay, we're seeing that if we're going to convey this power here, if we broadly define emergency, then the next administration, an AOC administration, for example, would also have this broad presidential authority. And that's interesting. That's kind of in line with what Neil Gorsuch really has focused on these past few years, is the separation of powers issues, right? Is exactly who is delegating this power and whether the president is operating outside his given Article 2 power here. And if this is granted here, what are the consequences of the actions down the term? SCOTUS is always concerned, of course, with how these interpretations, how these decisions are going to reverberate years later, right? So they believe if they're going to issue an opinion, it has to stand the test of time, and it has to withstand scrutiny not only from conservatives, from of course, from liberal perspectives as well.
It's funny, I read a piece early in the week that said, just get over it. The court's going to side with Trump here. But I must say, after listening to some of the arguments yesterday, I'm not so confident. First of all, I never count on Roberts, ever. I always assume Roberts is going to vote with the left of the court, and I'll be pleasantly surprised if I'm wrong. Then you lose Gorsuch. Now you only need to lose one more, and I could see it. I mean, I could see where this court does not side with the president, although I think they'll, as you said, with Roberts, split the baby if, in fact, they say no to Trump's tariff policy. They write it in such a way, right, that says, okay, well, what you've done heretofore is fine. We'll leave that alone. But going forward, XYZ. Is that about right, if that's what they do?
I think it's going to be divided. I think you saw each of the justices focus on their own particular issue. Let me be clear here. The Trump administration has to be right in every single one of these issues, right? The MQD, the major questions doctrine, is not applicable. Their statutory reliance is not applicable, is good. Their interpretation of what is an emergency is good. Their interpretation of what regulate is good. They also have to be able to say that this isn't a tax, that Congress, the question here, this is even a broader issue, is whether Congress, if this is interpreted as a tax, now we're saying this is revenue raising. We know that Roberts, if you look back on the healthcare, the ACA decision, that he broadly interprets the congressional power to levy taxes. So whether that's even delegable to to administrative agencies or the presidency. And so the problem here, Chris, is Donald Trump has to be right in about 5 or 6 specific issues. The people challenging tariffs only have to be right once for this to be. And so I think that's why I am guardedly, I am skeptical about this. And you saw some questions. The question from Gorsuch was particularly problematic because it kind of telegraphed where he is on this. And then, of course, ACB was really focused on the textual interpretation here. What does regulate mean? What does emergency mean? And there have been some good arguments that were proffered on the other side. Interestingly, Chris, this was, if you look at the amicus briefs filed in this, now Landmark Legal Foundation didn't file an amicus brief in this case, but they were really in balance. There was a lot on the side of the challenging. You had conservative and libertarian organizations. You just indicated Stephen Moore, for example. You had Cato Institute, other groups that were siding on the other side, on the anti-tariff, if you want to say that position. So we'll see.
Well, Michael, your analysis really helpful here, and we'll continue to watch it. I know you will, and as we learn more, if we know more, we're going to have you back. So thank you so much for your time this morning.
My pleasure, Chris. Have a great day.
For full shows, live and on demand, it's Salem News Channel. Stay informed anytime, anywhere with the Salem News Channel and 9:30 a.m. TheAnswer.com. This has been The Daily Answer, sponsored by Salem Surround on The Answer Now TV.